Reference to arbitration and deed of arbitration. So arbitration agreement is the form of alternate dispute resolution wherein the parties can refer a dispute which arises during the course of business transaction to a third party who is neutral and preferably an expert in the subject matter and resolving them. So the decision of such an arbitry is final and binding upon the parties, and the scope of its appeal to a higher authority is very limited. So arbitration may be of ad hoc arbitration or institutional arbitration. So ad hoc arbitration, here the terms regarding a number of arbitrators, the principal seat of arbitration, language, etc. is set by the parties themselves, and the parties are at an option to decide the terms as per their convenience mutually. In institutional arbitration, these are established permanent arbitral institutions which are governed by their own set of rules, and parties when referring these disputes to them are then governed by their formal terms. Example: International Court of Arbitration, London Court of International Arbitration, Federation of Indian Chamber of Commerce and Industry. Now the contents of the arbitration agreement. First, there should be details of the contracting parties, the legal name, the address of operation or the registered address, details of the nature of relationship that is between the parties, then the nature of the dispute which can be referred to in the arbitral tribunal, the detailed subject matter, the procedure of referring the dispute, period of notice before invocation of arbitration, then the principal seat of arbitration like the city, then the governing law for the arbitration, number of arbitrators, their qualification, the process of their appointments and their powers, whether modification of agreement is allowed, and if it is allowed, then the procedure that is to be followed must be mentioned. A statement that the arbitration agreement serves as a bar to the disputes. This implies that the disputes mentioned shall be taken to the arbitral tribunal only and not to the courts. May even mention whether the cost to be borne by one party or by both. Commonly, the cost of arbitration is split between the parties and may be claimed as a part of the award. Then, a statement that the arbitration agreement shall stay in effect in respect to the subject matter of the primary agreement even after the primary agreement ends or stands terminated. Then, the place and date of execution of agreement. Then, the name, designation, and signature of the authorized representatives. Now, the essentials of arbitration agreement. So, the existence of a dispute is an essential condition for arbitration. Where parties have effectively settled their disputes, they cannot refuse the settlement and invoke an arbitration clause. So, first, it should be a written agreement. An arbitration agreement must be in writing, and it should contain the document signed by the parties, an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not defined by another. Then the intention. So, the intention of the parties is of prime importance, and no form has been prescribed for an arbitration agreement, and nowhere has it been mentioned that terms like arbitration, arbitrator are essential prerequisites in an arbitration agreement. According to a leading case law in this subject, the intention of the parties to refer their dispute to arbitration should be clearly distinguishable from the arbitration agreement. Then the signature. So an arbitration agreement needs to be signed by the parties. The agreement may be in the form of a signed document by both the parties containing all the terms, or it may also be a signed document by one party which contains the terms and an acceptance signed by the other party. It will suffice if one party puts his signature in the written submission and the other accepts it. Now, the points that are to be remembered while drafting an arbitration agreement. The seat of arbitration. So this clause specifies the seat or the place of arbitration, which should be determined, and the procedural laws that govern the arbitration procedure. So it need not to be the same as the place of hearing. Seat by arbitration is considered to be the place where arbitrations are held, even if the place of hearing differ. Place of hearing don't by any means affect the chosen seat of arbitration. Then the procedure of appointing arbitrators. So this is about the appointment of arbitrators. So this provides, section 11 provides that a person of any nationality may be appointed as an arbitrator unless otherwise agreed by the parties, and the parties are free to agree on a procedure for appointing the arbitrator. If the parties fail to reach an agreement in an arbitration with three arbitrators, each party shall appoint one arbitrator, and the two arbitrators shall thereafter appoint the third arbitrator, who shall be the presiding arbitrator. The appointment of parties may be by the parties themselves, or by the designated authority, or by the arbitral institutions. In places where the dispute involves international commercial transactions, then the arbitrator to be appointed shall not be of the same nationality as the parties to the dispute. Then the language of arbitration. So it is important to mention the language of arbitration in the agreement itself, especially in a country like ours where Hindi and English aren't the only two languages spoken. It would get very difficult to decide and settle the disputes. Choosing the language of arbitration is also very cost effective because it would save you from paying exorbitant fee to the translators. Then the number and qualifications of arbitrator. So according to section 10 of Arbitration and Conciliation Act of 1996, parties can determine the number of arbitrators provided that the number is an odd number. Following to determine the number of arbitrators, the arbitral tribunal shall consist of a sole arbitrator. Then the type of arbitration. So the parties can choose between the institutional or the ad hoc arbitrations. If the parties choose the formal, then they have to be bound by the rules of the arbitration of the institutions. All these institutions have their own set of rules for arbitration, and these rules would be applicable to arbitral proceedings conducted by them. Whereas if they choose ad hoc arbitration, then arbitrations are both agreed to and arranged by the parties themselves, and no help is sought from the arbitral institutions in ad hoc arbitrations. Then the governing law. So this is the law that governs the main point of contention between the parties to a dispute. It is even known as the substantive law. The parties should mention the law they want to be governed by, failing which may give way to disputes in the future. Then the name and address of the arbitration institution. So if the parties to the dispute are referring their disputes to an arbitration center, then it is pertinent that they mention the name and address of the arbitration facility in clear and unambiguous words. Such inadvertent mistakes can lead to the nullification of the arbitration clause. That's all. Thank you.